your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make your whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome all the new subscribers to this channel. Thank you for your support. Thank you very, very much for your support. So today is Judge J Cedric Simpson, one of my favorite judges. Now, somebody mentioned yes, these judges try to be sympathetic and try to help people, but you got some people are just hard-headed, as we saw with Judge Fletcher yesterday. Some people are just hard-headed. Share screen. Doesn't full screen. And we're ready to rock and roll.
Back on the record in case people say to Michigan versus James Whitley.
No.
Typically, oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett, appeared with me, Mr. Whitley, sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that, unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that he that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense. But also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern,
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No,
Was that said to the prosecutor?
that was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
Well, there were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Does that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it said?
because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. I don't think it is. Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
Wix, one platform, any website, unlimited creation.
Proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my positions are. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counsel. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. That behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss and you
I did not.
if you start this exam. she's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. Right.
She took it as a threat. What was she supposed to take it as?
Well, get him, Judge Simpson.
She took it how she took it. I mean, that was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule?
I felt this case was different because this is not a situation where, this is a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
Hello, my name is Adam Ferrari, the Chief Executive Officer of Phoenix Energy. I look forward to you.
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him with the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Sabat.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that,
And I don't think you want that.
Get him, Judge.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice.
Get him, Judge.
Court's in recess.
Get him, Judge.
All rise. Back on the record in case of the people, State of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsel say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now, knowing it, as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification, and I would.
As to identification of
The defendant. So it's very brief, and I don't want to have to bring the lay person back.
understand. Mr. Bennett.
I would stipulate to the identification.
Uh-oh.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only.
July 1st at 10 a.m.
I realize that gets close to a holiday, but will that work for?
I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down. It does call the case of VMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. All right. Thank you. I will note, Your Honor, that filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous. quite nervous. But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down. You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else and then
No, I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
was
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
Oh.
I don't know what you need to do, but
Oh, you don't say that to a judge.
Let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court. So I don't know why, on those grounds, why I'm hearing from you.
Okay.
I know that's right.
If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
Hold on. Okay. Okay. No.
You have a lease with, allegedly, with Miss Whitman.
Correct.
That's
Then
right.
that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
what,
Because you don't have, there is no
You too.
privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know
communicating
that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlows did, the,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with DMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month
Ouch!
that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payment.
I know. Idiots calling. I watched the construction of a 12-story luxury senior home being built in San Francisco. It's called Cartery Cathedral Hill. A one bedroom in that place is $10,000 a month. No shit. Yeah. 1 month in that place is $10,000 a month for a single bedroom.
This was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order.
She doesn't. She's a plaintiff.
Thank you.
Thank you,
Okay.
Your Honor.
Thank you.
I know, you didn't.
Limu, I drive. You help people customize and save with Liberty Mutual.
Do you know what's actually in your tap water?
Yes.
My name is Johnny. I am an engineer.
Court does call the case of the people versus Terrell Green.
Good morning, if you're Richard McDuffie, people.
Good morning, Your Honor. Gloria Aki, Assistant Public Defender, with on behalf of Mr. Green, who's appearing via Zoom from Jackson County. Mr. Green, can you unmute yourself and state your name for the court?
Yes, Terrell Green.
Thank you, sir. All right, what do we do?
Your Honor, I don't, is there an offer in this case?
Your Honor, so Ms. Yankee reached out to me yesterday. However, I just saw that Mr. Green has 2 unreviewed warrants in our system. So I'm going to need to get those reviewed and charged, so that we can figure out any possible resolution of that.
In that case, Your Honor, Mr. Green.
You'll need to fill out a green sheet, but go ahead.
Yeah, he's in Jackson County until the 25th. So I know we are hoping to have these come in before then. I guess, Mr. Green, do you want to ask for an adjournment until the 17th, or do you want to just set it for exam?
I'm sorry, say that again.
Well, I don't know that we ought to have that conversation out here. Mr. Green, when you get released on the 25th, are you then going to be out?
Yes, I believe so, yes.
Okay, so you're not going someplace else or anything like that. You'll be done.
Yes, I'll be done, yes.
All right, here's what I'm going to do then. Is it May 1?
Sorry?
May 1, isn't it?
Yes.
All right. I'll expect the green sheet, Ms. Yagi. I'm going to adjourn your probable cause conference to May 1st, 2025 at 9 a.m., or as your invite indicates. All right. We'll just do it that way. Fair enough? That work for you, Mr. Green?
Okay, Gail.
Oh, yes, yes.
Okay.
Thank
All
you.
right. Bond will continue. Thank you. Court does call the case, People versus James Sharp.
Morning, Your Honor, actually, Lonnie, people.
Good morning, Your Honor. James Platfelska, appearing on behalf of James Sharp.
Mr. Sharp, can you state your name, please?
James Sharp.
Thank you.
Your Honor, I believe all of the discovery is in. I just received some yesterday, so I would be asking the court to set this for preliminary exam.
15.
Yeah.
All right. Would the people have their witnesses available to 15?
Your Honor, I don't believe that date will be able to be accommodated. Mr. Sharp is currently in Livingston County Jail and is also being held in a federal case. So we're gonna need, so we're gonna need a little bit of time to coordinate whether or not we'll be able to transport him in person for his preliminary examination.
No objection.
29th be enough time? Is that-
Work on it. Your Honor. Thank you so much.
Yeah, that should work for me as well, Judge.
Preliminary examination in person, April 29th, 2025, 9 a.m. before me. Bond will continue. Thank you. Thank you, Mr. Sheriff.
Sir.
Court does call the case of the People versus Stephen Smith.
Joseph Ignaldo, people, Assistant Public Defender J. on behalf of Mr. Smith in all cases not ending in 5506, Your Honor.
James Fatfelski, appearing on behalf of Mr. Smith in 5 case.
Okay.
Your Honor, we're here for PCC today. I did request an adjournment on this case for a couple of weeks as I am pending approval with the Monroe County Sheriff with my client. It's a process that I'm going through currently. I expect to be approved hopefully in the next few days so I can talk to him. I would ask that Mr. Smith call my office tomorrow so I can have some preliminary conversation with him.
All right. Your Honor, the same applies to me. I've been trying to coordinate a date to meet with Mr. Smith at the Monroe County Jail. It's harder than it is here, I'll just say that. So we're also asking for an adjournment.
You think 2 weeks is going to be enough, or?
Well, I think for purposes of, we're going to need a written order again anyway. Yeah, so I think for purposes of the writ, Your Honor, we'd probably be asking for 3 weeks.
Well, 2 weeks for the writ, but I'm thinking about you guys getting in to be able to talk to him. I can do the 17th or 24th, pick a date.
24th works for me, Judge.
This is a green sheet for Mr. Fatfelski on your
All right. So, thank you. So I'll adjourn these matters to April 24th, 2025, 9 a.m.
And Mr. Smith, please call my office tomorrow.
Bond in all of these matters will continue.
Thank you.
Thank you. Thank you.
Thank you. Thank you.
Thank you. Court calls case People versus Jacob Jackson.
Your workflow is important to us. Please wait indefinitely.
With Monday.com's intuitive work management.
Morning, Lord Agnes. Well, the creditor on behalf of Mr. Jackson, who appears to be. So, Mr. Jackson, could you state your name for the court?
Jacob Jackson.
All right, thank you.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
All right, thank you.
Your Honor, I apologize. I'm going to have to fill out a green sheet for this as well. I am asking for an adjournment. This was adjourned previously to follow up on the cash bail that Mr. Jackson paid in Ohio. I was able to get the case number verified with the clerk, but it was a surety bond, which complicates things because I'm not sure that that cash could possibly be applied to its balance. So I would ask for some.
Well, it can't be.
It can't.
Yeah.
That's what I thought, but regardless, I'm asking for some additional time for him to be able to make payments to come towards a resolution of this case.
Well, how much time are you looking at? I mean, I don't.
We would ask, I mean, frankly, however much time the court's willing to give us, to be candid.
Without objection, April 24th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you.
Thank you.
Thank you.
Court calls case of the People versus Kyle Burmeister. Good morning.
Good morning, Your Honor. James Fatfelski, appearing on behalf of Mr. Burmeister. Your Honor, this is the case we've been working on a potential misdemeanor resolution with another pending misdemeanor case. It's come to my attention moments ago that there is a new felon being authorized, so we're gonna have a little more difficulty with that. Given that fact, I would still ask that this be adjourned, so at least you can see the whole landscape before any decisions.
Any objection?
No, Your Honor, that's correct. I believe Mr. Burmeister is going to be arranged today at 1 for an hour up to 7.
Got it. April 24th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls the case People versus David Berman.
I'm here.
Go ahead, Madam Attorney General. You put your appearance on.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And good morning. I would do this on behalf of David Furman.
Mr. Furman, you got a camera?
Yes, sir.
All right. State your name, please, sir.
David Lee Furman.
All right. What are we doing?
We're an offer that was based on the client mail checkout and I'd be asking for an adjournment resolution.
The delivery date. I don't.
He was to pay for the expedition And upon completion of that payment, the prosecutor would go to now the process.
I'll just, April 24th, 2025, 9 a.m., and we'll figure it out. Okay. Bond, continue.
Thank you.
Court does call the case of the people versus Derek Graham.
And then on behalf of the people,
Oops.
Where'd he go? Mr. Goldstein. Your name, sir?
Derek Graham.
Thank you.
Mr. Goldstein is on another call. He was wondering if the court may pass on this matter.
You don't have much of a choice. You didn't want to tell, I know, you didn't want to tell me that. I'll pass it, take it back. Court calls the case of the people versus Joseph Wynn.
Assistant Public Defender with on behalf of Mr. Wynn. Mr. Wynn, can you state your name for the court?
Yes, ma'am.
State your name, idiot.
Yeah, I didn't hear. State your name again, sir.
Joseph Wynn.
Thank you. Go ahead, ma'am.
And good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
All right, what are we doing?
Your Honor, this is another matter. Again, I apologize. I did not fill out a green sheet, but I am asking for an adjournment. Mr. Wynn, this is a fairly recent case, and he just got a new job. He's on payroll, so we're working towards resolution.
Okay, without objection, I'll adjourn this to the 24th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond, continue. Court calls case of the people versus Daniel Greenwood.
Big ideas.
There you go.
Your Honor. James Vitfelski, on behalf of Mr. Greenwood, I'm standing in for Mr. Elman, who's could not be.
And Your Honor, on this case, we did submit the petition for probate court, and I believe, Mr. Greenwood will be going into treatment to be filing now.
You're filing Nolly today. Any objection?
No objection.
All right. I'll indicate this case is dismissed. All right, thank you.
Thank you, Your Honor.
Court calls case of the people versus Candace Holmes.
Joseph and all those people.
Your name?
Candace Holmes.
All right. Probable cause conference will be adjourned April 17th, 2025, 9 a.m. All right, thank you. Bond, continue. Court calls case of the people versus Brendan Chrysler.
that's a lot of people.
James Vitfelski on behalf of Mr. Chrysler, who is approaching. Your Honor, in this case, my client just got out of treatment in the hospital. Two requests, I'm guessing the court will want him to test today. He has been basically indisposed and unable to test because of that. I'm asking for an adjournment to the 24th review file with my client. The good thing is his father is here. He's been very communicative with me. I have not been able to communicate with my client since he's been in treatment in the hospital. And I'll also note he is on probation in Allen Park, so it's my understanding they're also beginning drug and alcohol testing with him, which should be double sort of testing here to ensure that my client will be clean and sober aside from what he's.
Ms. Lundy.
Does the court have a copy of the community corrections report from March 19th.
Yes, I did.
So according to that, it looks like the event precipitating the defendant being hospitalized was an overdose. And I'm not sure that we've had any tests from him at all. So I would request that he be tested today before he's allowed to leave and kind of go from there.
That's fine, Judge.
Where was he in treatment?
Well,
Because I have no documentation about treatment either.
at the last PCC, I had a screenshot of a statement from one of the therapists there to verify that. I did not actually print it out. I can do that later, provide it to the court. That is where he was at treatment. And then he had a medical situation, went to what hospital? DMC. And I think he was just discharged a day or two.
So if we test you today, you're gonna test clean?
Yes, Your Honor.
All right, so we'll need an order. I need you to go over to community corrections. I'll pass this matter.
Thank you, Your Honor.
And then,
Will that include ETG?
pardon?
It'll include ETG?
Yes.
Thank you.
Court calls the cases of the people versus Robert Lewis.
People.
All 7 cases.
Sure. Assistant Public Defender Hannah Apple stating in for Mr. Feaster on behalf of Mr. Lewis.
Good morning, James Kowalski, appearing on behalf of Mr. Lewis on a case ending in 1113.
Your name, sir?
Robert Van Lewis.
All right.
Your Honor, I did submit a grievance. I'm asking for an adjournment for some continued negotiations.
I am as well for, to obtain discovery and review that before we proceed.
All right.
Could have the 24th, that would be my request.
So what happens when people request dates? They don't get them. April 17th, he's in custody. 2025, 9 a.m.
Judge, I do have a conflict. I'll be in Lenawee County on another court matter, so.
You mind your client being in another week, Miss App?
I'm sorry.
Your Honor, Mr. Feaster is the one that spoke to Mr. Lewis. So I would do that to him. I think that we could work something out regarding Mr. Kowalski's appearance and do a step to adjourn.
17.
That'd be great. Thank you.
Court calls case people versus Julia Sosinski.
James Vitfelski on behalf of Mr. Linsky, who is approaching. Your Honor, I'm asking for an adjournment. There is some outstanding discovery that Mr. Linsky obtained to get over to me. So I am requesting a 3-week adjournment.
What are you trying to get over to?
There's a supplemental discovery report that, discovery request, excuse me, counsel, that's over. One of my colleagues is emailed that. Information I was given, so just an opportunity to get that.
April 24th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you, Your Honor.
Court calls case people versus Christopher Willis.
Andrew Childers, bring on behalf of the people. Edward.
Thank you.
It's time dates up. I'll ask next week. For so you can make up second court text waiver.
Sir, you're waiving your right to a preliminary examination?
Yeah.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand that? You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
You're not, I acknowledge receiving the information standing.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 16th at 1:30 for Judge Conlon.
April 16, 2025, 1:30, Judge Conlon.
Yeah, my name is John.
You may.
You're very familiar with this. I brought this up two other occasions. What has changed, I think you spent next week to in custody regarding his acknowledgement that he has to follow the rules. I'm actually witnesses.
They've taken this video down 3 times because it teaches you how to hit lottery tickets every week. Watch now while it.
Allegations are 2 existing charges, and he has no contact with Mulder's children. And they're working on a housing situation. Need to find an appointment that's set for the end of April. The no contact individual is here today. She certainly could.
Has she had talked to the prosecutor's office?
I did speak with her this morning.
All right.
I think with him spending time in jail, knowing that he had the order not to have contact, he had contact and was arrested. Based on that contact is brought before Your Honor. I think going forward, that no contact order is lifted, he will abide by any other order that the general contact. Not to make light that he will violate the order.
I think that was
Defendant's bond at a $10,000 personal recognizance bond. So we'll release him at this point. We'll indicate that we will add no non-consensual contact. You understand that, sir?
Yeah.
And I will delete the no contact provision.
Just to adjust, I don't believe a no go to.
I don't think that's what I was gonna ask. I don't think there is. Given the circumstances.
You don't mean no go to the speaking all of this.
Right. So that no go to will stay in place. All right.
Thank you very much.
Thank you. And did you just fill out that form? Thanks. Court does call the case People versus Lawrence Buckner. Who just stepped out? Pardon? Approach on this matter?
No,
On, okay. State your name.
Lawrence is a family bug.
All right, go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Buckner.
All right, what are we doing on this case?
Yeah, I have received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that? No.
Your Honor, I don't object to setting out for exam or to defense counsel's request. However, I believe counsel is new on the case, is not aware of something that provides the public of Earlier this week, this defendant made threats to witness a preliminary examination. And you charge,
Sir, you need to face me.
and you charge an authorized against this defendant as a result of these conduct. And as a result of that, you charge being authorized, you were requesting remand. We have previously advised the defender's office.
Judge Rand Washington is in the office.
Your Honor,
Your Honor, this is,
Sir, I will give you an opportunity to address the court, but you're not going to interrupt You're not going to interrupt anybody. You're interrupted. Yes.
Alexander, on behalf of the people, this exam was held on Tuesday, and after the victim in the case had testified, Mr. Buckner, during a break in the exam, threatened her in the gallery, and we did end up charging him with threatening to injure a witness. And this is a victim that he was not supposed to have contact with, as she was a victim on the FA case. So in that sense, he had violated the bond by contacting her in court and also threatening her with criminal charges, which is why we would be asking for this bond to be revoked.
Sir, what did you want to tell me?
sir.
Well, Mr. Buckner, I advise at this point you don't make any statements.
Mr. Johnson, I need to speak because if I don't speak, if the prosecutor said they want to lock me up in remand, it's up to Judge Simpson. So I have to present my portion of the truth. If I don't, I'm going to jail. Like, I have a family to support. Please, like, I am not guilty. And this is what I, okay, okay, on Tuesday, I had a hearing for a situation that I was allegedly accused of, right? During that hearing, is my belief, so let me just say that, it is my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was on, and I was talking to them, and nothing out of my mouth said, I'm gonna threaten that lady, I'm gonna get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times and 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify on who shot you. You need to testify on who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family, I got my brothers here, I got a few that I support. I don't want nobody getting killed else. I died twice in my brother's arm. The next day, I got in an incident with my lady friend, and it went from a domestic violence to a stalking. Ypsilanti police officer Tyson came in to Washington County Jail the very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it, I didn't do anything wrong. The next day I woke up, I had stalking charges. That was dismissed. That was the malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I come to court, and the prosecutors, Judge Rand Washington is an eyewitness. This same prosecutor, while we was in court on camera yesterday, sir, while we was on court on camera, just please hear me, said Mr. Buckner is threatening my witnesses in court. This is what this same prosecutor said. Judge Rand Washington said, no, he's not.
Do you have an old or damaged roof and you're looking to finally do something about it? We're Roofing World, a top-rated roofing company.
Mr. Buckner is talking to me, and he's not threatening. See, they had already had it out.
Hold, stop. There was a video requested. Does the video show anything?
Yeah, I haven't had a chance to review it. I just got it this morning. But we were informed immediately after the threat occurred. I did, she informed our advocate, and then informed us that it didn't happen. And then she did a police report, and then we authorized the charges.
Your Honor,
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
Your Honor, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Your Honor.
Yeah. Mr. Brown, were you there on that?
I was not, Mr. Michael. First of all, one round deputy. I was not there, Mr. Michael Gaddy was. I'm not sure is this being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things there, and I don't know what there was a request made for video from this courtroom of that day. We got time narrowed down. You need to take your hands out of your pocket. And the request was made. I checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. That was, I think, Byrne provided to the people in this case. They have not had an opportunity to review it.
So as it stands now, these allegations that they have filed on each charge.
Well, no, it's basically charged. It's authorized at this point. It's just that it hasn't come through the system yet. Okay, so here's what I'm going to suggest, and it may not like it, but I think maybe this is the way to do it. The video, somebody from your office, Mr. Brown, was handling his exam, correct?
Yeah.
Okay.
We just talked about it.
He didn't see anything. So what I would do, and I get Mr. Johnson's point, he's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video provided to Mr. Buckner. Mr. Buckner. I don't know what's on the video. I did not view it myself. And then have counsel look at the video, and then I will myself look at it when I get a break to be able to do so, and then make a determination if based upon that, his bond in this case should be revoked. I think that's probably the fairest way that I can potentially do. Yes, sir.
Sir, I appreciate you first and foremost for this opportunity. And I say this to the court that upon looking at the video, the prosecutor said that I want the whole court to hear it. I physically said that I was going to threaten and get this woman.
Sir, first of all, I don't want you saying anything about what's going to be that new case coming up. I don't want you saying anything. I'm not going to hear it because you're going to end up hurting yourself. What I have said is you will be going into custody. We will then, and I'm not saying even at this point, I'm going to keep you in custody. A video was requested. I'm going to give, the prosecutor's got to look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with your attorney at that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out at least preliminarily.
Mr. Judge Simpson, I'm a very honorable person. I'm asking in all due respect. I'm not a flight risk, sir.
Sir, I'm not saying that you are.
My dog's in the car. Is there any way that I can call my brother so he can come?
Sir, I'm gonna expedite it as best I can to make sure that I can look at it, get you recalled back up and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it, but it affects his case. But the people that can look at it can do that and maybe get in touch with Mr. Johnson. I don't know, but I'm just saying that's the way I'm gonna handle it at this juncture. All right?
You don't represent me. Okay. So the guy that represents me is Mr. Guy. Mr. Guy is the key factor in you being here.
Okay, look, Mr. Buckner, they'll be able to talk to you back there, but I'll pass the matter. Sir, you need to just quiet down, please.
Are you like the millions of Americans who have recently opened up their auto insurance bill only to ask the question,
Of course, we're well descendants doing the video.
All right. And Mr. Brown's going away. Okay, thank you. Got it. They just put in. All right. Court does call the case. People versus Spencer Norton.
If you were to move it for people.
They're all.
Morning, Judge Simpson on behalf of Spencer Norton.
All right, what are we doing? And Norton,
Yes,
can you state your name, please?
Spencer Norton.
Thank you. What are we doing?
Yes, Judge, we're seeking an adjournment for an opportunity to review the discovery and work towards a resolution.
Without objection, probable cause, April 24th, 2025, 9 a.m. Bond continued.
Thank you, Judge. Have a great day.
Thank you. Court calls the case, People versus Anthony Taylor.
Good morning, Your Honor. David Kennedy, active people.
James Beckett, on behalf of Mr. Taylor, approaching. State your name for the record, please. Taylor. Your Honor, I just received late yesterday an additional video discovery that is important in this case. I'm asking for an adjournment so I can review that. I also review that with my client before we proceed.
Is this the only thing holding him?
I believe so, yes, Judge. It is a capital case, so I'm asking for the 24th. It's a case we really need to prepare well
for. He's in custody. Again.
And have a conflict on the 17th.
I know, it was just a few minutes ago you told me that, but any response from people request for?
No, Your Honor. There is additional video certified on camera. It's a counsel, also needs to be sent to the counsel. But other than that.
24th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus Trayvon Addison.
National people. And then to have a fair afternoon, Your Honor, on behalf of Mr. Trayvon Addison, Mr. Addison, take your name to the record.
There's Trayvon Addison.
Thank you.
Judge, we respectfully request that this matter be set. People may attend.
All discovery is complete.
To our knowledge, Judge.
People have their witnesses available the 15th.
No, Your Honor. I will try that day. Thank you.
Preliminary examination in person, April 15th, 2025, 9 a.m. before Judge Moore. Thank you. Bond continued. Court calls the case of the People versus Michael Colleton.
Assistant Public Defender Brazil is on behalf of Michael Collinson, who approaches. Mr. Collinson, please state your name for the record.
Good morning, I'm Scott Collins.
All right.
Your Honor, we're asking for an adjournment for a plea discussion, and I would ask to address comment.
Of course you would. Probable cause conference will be adjourned April 17th, 2025, 9 a.m. as to bond.
Your Honor, we are asking for release to treatment in this case. Mr. Collinson is currently serving a 1-year sentence on a separate case that he has with you until next year. He really understands that his substance abuse problem has led him here. He wants to get help. He has been participating in the MAT program while in custody, but he also did pathways to recovery and got harm prior to being in custody.
Let me stop you. I'm not going to have a problem with release to custody. Has that been coordinated with the case he's under sentence?
No, I believe that Ms. Kearney has brought it up with you in the past, but it has not, you have not ordered release treatment on that case, but she will be asking to.
So prepare an order that would encompass that. I'm not going to have a problem with release to treatment. But right now he's under sentence, so I could sign whatever I want. On this case, he's still going to be held. So let's get both of those cases set for that. I'm not going to have a problem with that. We got treatment. All right. Bond continue.
What was the new date, Your Honor? I'm sorry.
The 17th.
Thank you.
Court calls the case People versus Laura and Dia.
That's a lot of people. It's not very, Your Honor, for India approaching. Ms. India, say your name for the record, please. Laura and Dia.
Thank you.
Does the question have a green?
I don't have one.
I think it was wrong.
Did you do one? Or you just, no, you didn't. You didn't, did she do one? And just left it there even though the case was called?
I'm sorry.
No, you're not. It's just kind of the way you roll. You want an adjournment?
Yes.
How long would you need?
I think 2 weeks.
Probable cause conference, April 17th, 2025, 9 a.m. Bond continues. Thank you. Court does call the case, People versus Emily Bates.
Assistant Public Defender, Skinner Admiral, attorney on behalf of Ms. Bates. Ms. Bates, will you please state your name for the record?
Emily Bates.
Here we're asking for an adjournment for continued negotiations.
Where do I have? Oh, you filled that up. Whatever. Probable cause conference without objection, April 17th, 2025, 9 a.m. Bond continue. To the People versus Jacob Dorstein.
Assistant Public Defender, Chelsea Burfield, with contact with David.
Jacob John Dorsey.
All right.
We're asking to adjourn to give us time to create a mitigation report. I believe the turnaround time for that is about 6 weeks.
6 weeks?
I believe that's how social workers ask to speak with Mr. Gross and get to know him.
Well, you need to tell your social workers they're gonna have to work fast.
Can we,
You want me to tell them?
Yes.
Speak him in for a month if the court would prefer.
Probable cause conference, May 1st, 2025, 9 a.m. Bond continue. I mean, I'll talk to them. Just give me some names. I'm not shy. Court calls the case, People versus Leon Booker.
Lobby standing in for Alexander people.
Assistant Public Defender J Cedric on behalf of Mr. Booker, who approaches. Mr. Booker, can you please state your name for the record?
Thank you.
Your Honor, we are asking to set something for a preliminary examination.
All right, and all discovery is complete.
Yes, Your Honor. To the best of my knowledge.
People have their witnesses available the 15th.
We'll try, Your Honor. Thank you.
Preliminary examination in person, April 15th, 2025, 9 a.m. before me. Bond will continue.
Thank you.
Court calls case of the people versus Devin, is it Gothard?
Entertaining for the people, Your Honor.
Get an apple, drink coffee now. Thank you. We're asking for an adjournment. We have some additional investigation to conduct, and then I would ask to address bonds.
Probable cause conference will be adjourned without objection, April 17th, 2025, 9 a.m. as to bond.
Your Honor, we are asking for a reduction in bond and or a 10% option. Mr. Gothard does have employment at Bob Evans and Taylor. He does have stable housing and Romulus with the design. He's asking for consideration for a home confinement tether and a 10% option for reduction.
All right. Response.
People will be against any modifications on this time, Your Honor. That does have a prior CSC second conviction from Oakland County in 2016.
From when?
Say that again?
When was this prior? Thank you.
He's, in this present case, he assaulted a victim when she was asleep, passed out at a friend's house. She had a stain hit done and left report did indicate that it was the defendant's DNA. Also, Your Honor, while police were trying to locate the defendant, they learned that he was one person that he intended to travel to Kentucky, and so another person that he had intended to travel to Tennessee. And Your Honor, I mean, someone willing to go across the state of Ohio.
Anything else?
Your Honor, I think that a home confinement tether would give the court the proper conditions for allowing him to be released. He maintains no serious allegations. He's asking for an opportunity to be able to work with our investigator regarding this case from autopsy.
Motion for bond reduction is denied. Bond will continue.
Thank you.
Thank you. You need.
Yeah, because I don't.
Court calls case of the people versus Grace Brenner.
Alexander on behalf of people, Your Honor.
Assistant Public Defender Hannah Apple, appearing on behalf of Ms. Brenner, who is here to be assumed. Ms. Brenner, will you please state your name for the record?
Good morning, Your Honor. My name is Grace Brenner.
Thank you.
They're asking for an adjournment. There may be some additional discovery that I
Probable cause conference will be adjourned April 17th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls the cases of the people versus Sean Charnley. 2, 3, 4, 5. All 5 cases. Clips. Oh, she's on that side. Okay, go ahead.
Austin Bashir, on behalf of Judge Farley on the remaining matters.
On which case?
I believe it is 888. And then there's also a third attorney who did put her appearance that she's standing behind.
There's a third attorney?
Yeah, the gentleman from Mr. Burgess's office. She's right there.
Okay, counsel? Are you from Mr. Burgess's office? Yeah, it's just talk. I know. No, you were just nonchalantly going wherever.
I'm sorry. Oh, I'm so sorry.
No, you weren't. We watched you right there.
Yes.
Okay, but go ahead. No, it's okay.
I review it on behalf of Mr. Charlie Lane. I'm standing in for David Burgess with my client's permission. Is that correct?
All right, Mr. Durkis, you're on which case? Well, actually not. Because I think Ms. Tieppo is supposed to actually be on that case. Because she's not been relieved by the court. Has anybody heard from her regarding Mr. Turner's cases? All right. What are we doing on all of these?
Okay, if there's one AI site builder you need to meet, this is Dope Tech from Wix.
I can start on the 25F55553 and 24F21301. We're adjourning these matters. There's a conflict which is identified in our office and we just go on.
So, hold it. So that, seriously?
Okay.
So, right. Okay, go ahead.
Okay, well, in that case, then,
That's why Mr. Burgess kind of is here.
okay, great. Then in that case, on the other matters that I'm representing Mr. Conley on, 04.
Is everybody asking for an adjournment?
No, these are different. So 0444 and 1611, Mr. Conley would like to demand hold before I.
All right, what are you doing on your cases?
On our cases, we were just appointed, so we are asking for an adjournment to request discussion.
All right. And Mr. Dukas, I've signed the order. What are you?
I have a written report. I'm asking for videos. They do not have those yet, so I'm asking for it.
All right. So which cases are you demanding exams on? He's got 5 here.
F1,
Give me last 4 digits. Okay.
1611.
All right. So the other matters, I will adjourn. Well, let's do it this way. On case ending in 888, I will adjourn the probable cause conference in that case to April 24th, 2025 at 9 a.m. I will also set a show cause at that time for Attorney Tieppo for her failure to appear.
Ouch.
In this matter. His bond will continue in that case. In the other matters, the ones that Mr. Burgess has, I will adjourn those also to that same date of the 24th. Probable cause conference. 2025, 9 a.m. Bond will continue on those cases. That's what you're gonna need to do. Show cause on that. Okay, in the other matter, all discovery counsel, the other 2 matters, all discovery is complete.
More knowledge, yeah.
People have their witnesses available the 15th.
That's fine. This is filing in 444 and filing in 611.
Yes, sir.
Yes, that's fine.
All right. Preliminary examination in person will be set for April 14th or April 15th, excuse me, 2025, 9 a.m. before Judge Moore. Bond and will continue in those cases.
Your
All
Honor, Mr. Court hearing scheduled for that date. We would possible.
Before whom? What time? So he wants a different day? Well, we'll keep the date. You guys figure out what to do. He can try to appear, do something. But I don't want to delay his preliminary. Then we're in agreement. Court calls the case. People versus Jeffrey McCullough. Your name, sir?
Jeff McCullough.
All right. What are we doing on this one?
Arrest, German. Basically, Chief Judge, I just served the court of motion for bond reduction. Scheduled for a new date of April 10th, and that coincides with this other case that was adjourned as well. And that's not missing for this court.
I figured that. Did you provide a judge's copy of the motion?
I provided it to the clerk. That's a hand order.
Okay, yeah, okay. Well, that might get to me by the 10th. But he has another case set on the 10th.
That's correct.
All right. So probable cause in this matter will be set for April 10th, 2025. You got that? 9 a.m. or is it your invite indicates? And your motion is on this case or on the other case?
This case.
On this case. So actually what will happen is I'll set it at 3 p.m. And all his PCC as well as the motion will be heard at 3 p.m. on the 10th.
Okay. So
Okay. Thank you. Bond will continue at this time. Court calls case of the people versus Kyle Beckerman.
Andrew Phillips, here on behalf of the people.
Peer review on behalf of the state name.
All right, thank you. What are we doing?
I'm not certain, I was just talking to
Yeah,
council.
I don't have enough time. What?
Okay,
You need to fill out a green sheet. You wanted to adjourn?
I'm sorry, I was just talking to council, so I need a minute just to fill out.
Okay, but you wanted adjourned in any event.
Yes, Your Honor.
April 24th, 2025, 9 a.m. Just fill the green sheet out. We'll get it
Is
signed.
that in the state of
Is there?
No, but,
Is there a community corrections board with testing?
okay, hold on.
I'm sorry.
Well, there is an order. Right, and I have a progress report from his testing, because he's testing. Well, my question is, are you testing at Harbor Oaks Hospital?
I tested the first time and then I was admitted to the hospital.
Right.
When I was admitted to the hospital.
They did a test.
Yeah, and I have paperwork for all that.
No, I got it in front of me.
Okay.
All right. So there is an order in place that he should be testing with community corrections. All right, so that's the answer to that question. I can give you the 17th. Is that what you want?
That would be.
Okay.
Hello, my name is Adam Ferrari, the Chief Executive Officer of Phoenix Energy. I look forward to you.
April 17th, 2025, 9 a.m. Bond continues.
I appreciate it. Thank you.
Court calls case, People versus Haley Gregg.
That's one of the people.
Morning, Brian Boyd, on behalf of Mr. Gray. Your Honor, we're asking that this matter be set for an exam, by mental health.
Will people be ready by the 15th?
We'll do our best, Your Honor. Thank you.
Preliminary examination in person, April 15th, 2025, 9 a.m. That's before me.
Thank you, Judge.
Thank you. Bond continue. Court calls the case of the People versus Antoine Perry.
Hey, here, the people.
All right. Your name?
Okay.
All right. And you're asking for an adjournment? All right. 17th work for you?
Yes.
April 17th, 2025, 9 a.m. Bond continued. Thank you. What are you? What, friends? What up? just checking. I don't know who you know. Court calls the case of People versus, is it Soloso Morales?
And then we got.
I just put it, oh, I put an extra syllable in.
It's approaching to my right. Please state your name on the record. Oh, Your Honor, and that gives us information to practice under Michigan Code 8.0 under WT.
Yeah, you were getting way ahead of yourself, huh? You just walked up like you, not like she could play in the sandbox. She like owned it. So permission to practice is granted. So
Morales.
that was it. All right, what are we doing? You have. I see the forms. All right, in the case ending in 350, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of stalking, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. In the other matter ending in 341, I have that same agreement, the 1-year offense of stalking. He'll plead guilty to that and count 1 would be dismissed. That is the court's full understanding of the. Has he signed advice right? Really? Oh, it's in 1. Okay. No, she's on top of it today. What? Okay. I have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony about your truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
State your name.
Soloso Morales.
All right, sir, it is this court's understanding that you are going to be pleading guilty to 2 charges of stalking. Is that correct?
Yes, Your Honor.
Okay, both of those are misdemeanors punishable by up to 1 year incarceration, $1,000 fine plus court costs, or up to 5 years probation. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in both of these matters in the 1482 District Court.
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty
Yes, Your Honor, I do.
to the charge of stalking as contained in case ending in 350. How do you plead?
Guilty.
To that same charge as contained in the case ending in 341. How do you plead?
Guilty as well.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form. Is that correct?
Yes, sir.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor, I do.
Are you on probation or parole?
Not current.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
and because you believe that you're guilty of these offenses?
Yes, Your Honor.
All right, starting in the case ending in 350. See if I can find my paperwork. Case ending in 350 on the date between March 11th, 2025 and March 16th, 2025. What did you do with reference to a Karis Poli that makes you think that you're guilty of this offense?
I violated my PPO.
All right, you had a PPO in place that you were to stay away from that person and not contact them?
Yes, Your Honor.
And you did contact them between those dates?
Yes, Your Honor.
On one occasion or repeated occasions?
Repeated occasions.
All right. In the case ending in 341, on the date of March 22nd, 2025, what you do is a reference to a Karis polling.
Same thing, repeated offense.
Okay, but that was on that same date. You violated the PPO
Yes, Your Honor.
of repeated contact to that individual?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Court will accept the defendant's pleas to count 2 in each case. Count 1 is dismissed. Pre-sentence investigation and report is ordered in both cases. Sentencing will occur
April 17th at 11 a.m. before Judge Barr.
April 17th, 2025, 11 a.m. before Judge Barr. Bond will
Your
continue.
Honor, may I just,
I knew it. Go ahead.
Your Honor, Mr. Morales is a 23-year-old devoted father of 3. He is the sole provider for both his mother and 3 children. He is actively working to better his life and enroll in school this summer to enhance his education and future job prospects. He acknowledges and completely regrets his violation of the PPO, and I believe it was just a misunderstanding.
Hold on. You're still purchasing your lenses from your optometrist?
What are you doing? Come on. Witness, there was no malicious intent anyway. If you were to look at those,
Pardon? There was no.
intent for him to, like when you're sending those messages to the complaining witness, you would see that they were not out of goodwill. They didn't know that it was a violation. Your Honor, to message him, to message her if she reached out first. It was all miscommunication. It wasn't done to purposely violate his PPO. Mr. Morales now understands.
Did he have knowledge of the PPO?
He did. But
Yeah.
he-
Oh, okay.
I think he just misunderstood that even if she consents to it, it still would be a violation, but now he's fully aware of that, which does not plan on ever speaking to her again. He just wants to take care of his 2 children and be a better father and a son to his mother. He has a home to stay with his mother, and his remaining witness lives somewhere else.
So when the first set of incidents occurred, he thought that was consensual? That was a question.
Yes.
And so then when the second one occurred, he thought that that same thing was still okay after being contacted about the first one?
No, Your Honor, that's, this, if I may, just.
Well, you got an attorney, so I don't know if you really want to talk, but go ahead.
Do you want me to remain silent?
No, Your Honor, I believe Mr. Morales, the first time it was a misunderstanding as to who reached out first. I don't believe that there was any contact on his end. The first time, second time there was, after the complaining witness did try to reach out, and he did reach out back.
Response from the people.
Your Honor, we'll leave it in the discretion of the court. But if you were to be released, we'd ask that you place on GPS tether, Your Honor.
And you understand, the PPO is still in place?
Yes, Your Honor.
And Mr. Morales expresses no intent to even think about this, Your Honor, let alone try to reach out to her. He just-
Well, that's what I'm trying to figure out. After the first case comes up, didn't he have that same feeling?
They were both around, I believe, like a week apart.
Yeah, but wasn't he contacted in between that week by somebody saying you shouldn't do this?
And I think
Well, was he?
he was.
And then what happened with the second one? That's what my question.
Then they proceeded to reach out to me.
And he didn't,
I didn't know that was.
So somebody told you, you had a PPO that told you you shouldn't contact this person. You were in contact with this person. When you were in contact with this person the first time, somebody told you you shouldn't be in contact with this person. And then they contacted you and you continued to contact them back because what?
I acknowledge that wholeheartedly, Your Honor. That was my mistake because it wasn't on them for me to be held responsible for what was in place for me. I do acknowledge that wholeheartedly that, may have crossed that line. And I don't plan on doing that again. I just want to put this.
How do you, okay, but you violated the PPO, which is a court order,
Yes, sir.
right? you were told after the first set of incidents not to contact this person. And then there was subsequent contact. So if I let you out now with that same admonition, how do I know that you're going to even follow the court's order?
I understand where this is going, Your Honor. I do.
No, you don't, but go ahead.
I don't, not all the way. My first time in, you know what I mean? I do wholeheartedly acknowledge that, though, that I wasn't in the right and control decision. And,
Your Honor, I have spoken with Mr. Morales in jail a few times over this past week, reminding him that if anything were to happen, he does not ever contact her. And he has expressed true remorse for his actions, and they were a mistake. And I do believe Mr. Morales now understands his PPO and what that means. And
He didn't understand it before?
he did. When
I'm just trying to gain a full understanding of what's going on in his head. Because you're gonna tell me this, somebody told him once, then told him again, and we have the same behavior, and I'm trying to figure out if I let him out, how do I have any?
Mr. Morales had time to sit in jail the past few weeks and really reflect on the fact that his kids are more important than trying to be in contact with the complaining witness and being a son to his mom and a father to his 2 children who are 3 months and 2 years old.
There's an original order, which is an exclusion zone for the tether, but I don't know if that exclusion zone still applies. Yes, we've had a, quite frankly, rather extensive bench conference. My understanding is that the defendant has a DV before Judge Barr, which he's set to appear on today. That in that DV, his bond is denied. But the reason his bond is denied on that case is because of the aggravated stalking, which was the one charge in this case. Did I have that right?
Right.
Okay. So here's what I'm going to do and what I indicated counsel I'll do. I will hold the files. I will at this time, I will deny your request for any change in bond. If after that hearing before Judge Barr, since he won't be before Judge Barr in these cases till the 17th, if Judge Barr releases him on the other case, then I will reconsider my decision on this case and may release him. Okay?
Thank you, Your Honor.
Thank you.
Thank you.
So at this time, his bond is continued. I'm gonna, what time is his hearing before Judge Barr?
It's at 11 a.m. Your Honor.
13 minutes.
Can we hold these? Court calls the case, People versus Brandon Carter.
People.
Mr. Carter, Your Honor, asking if you would call this matter at a later time. My client, he's en route. He
Really?
This is,
From where?
I think he's coming in from Detroit. When he called me, he had
Ipsy. He's coming from Ipsy, isn't
Your
it?
Honor, only thing I tell you, he was at the airport. His probation officer drove him to the airport, got on the bus, he missed whatever that bus, the first bus was, so he's getting on the second bus and he is riding it. He's called me with his ETA or where he's at, like multiple times today, trying to get here.
Didn't we do this last week?
Well,
With
Your
you?
Honor, last week, however, he was surprised by the request. This week he is getting here. He's just running behind, Your Honor. He'll be here, I promise. Well,
Okay, so if he's not, then I get to take you.
we.
You weren't gonna guarantee it to that extent, were you?
He will be here, Your Honor.
I know you promised.
I promise.
Yeah. Alan, what happens when I'm disappointed on my promises? Yeah.
So yes, Your Honor. He'll be here.
She's now going to pray he shows up. Court calls the case, People versus Chancel Bray Page. Your name, sir?
Ready, Your Honor.
All right, go ahead, counsel.
And greetings, Your Honor. Emmett Greenwood on behalf of defendant P56556.
All right. What are we doing on this case today?
Your Honor, I'm respectfully asking that the PCC be closed and this matter be set for an exam. If we could have April 15th, that would be perfect.
You know, when people ask me for dates, I sometimes just don't give them that date. But I will. Would the people have their witnesses available on the 15th?
We will try our best. Yeah. I'll leave it at that.
Preliminary examination in person will be set April 15th, 2025, 9 a.m. before Judge Moore. Bond will continue.
Judge Moore, thank you. Thank you, Ms. Ann.
Court calls case, People versus Andrew Castillo.
Still, moving to my right, standing director.
Thank you.
We're gonna adjourn this in order for Mr. Castillo to pay restitution. He has paid that. I received. I have prepared a knowledge process.
Any objection to that? So you're not gonna say anything? Okay, all right, I'm just checking. Case is dismissed. I'll sign that now when I get it. All right, thank you, sir. Mackey's like, yeah. Court calls case, People versus Sean Newcomb.
Assistant Public Defender, accountable. Please say your name for the record.
Thank you.
Got a asking for an adjournment, we need some additional time to specific negotiation.
Why do I have two in here? Oh, I know why.
Mr. Feaster, I didn't realize.
Mr. Feaster started just doing stuff. All right. Probable cause conference, April 17, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case of the People versus Antoine Coleman.
People.
We're asking for an adjournment, Judge.
Probable cause conference, April 17, 2025, 9 a.m. Bond continued.
Thank you.
All right. Thank you, Mr. Coleman. Court calls case, People versus Michael Robert.
And then nothing happened, people, Your Honor.
Frank Lloyd, Mr. Robinson. Judge, I'm just asking for Michael Robinson.
Probable cause conference will be adjourned April 17th, 2025, 9 a.m. Bond continued. Court calls case of the people versus Shauna Colston.
That's a lot of people. Here, Lincoln on behalf of Scott Wilson. I have not had an opportunity, I've not been able to reach Ms. Wilson to.
She's here.
Yeah, of course, we've been unsuccessful in being able to discuss the case, so I've submitted a read sheet, just to have a brief adjournment, just to counsel.
Your name, ma'am?
Shauna Colston.
Probable cause conference without objection. I'll adjourn to April 17th, 2025, 9 a.m. Bond continued. Court calls case people versus Derek Graham.
They've taken this video down 3 times because it teaches you how to hit lottery tickets every week. Watch now.
All right. And what are we doing?
Sitting for exam, Your Honor. I have no objection if you said the same time.
And all discovery is complete.
As far as I know, yes, Your Honor.
Would the people have their witnesses available on the 15th? Preliminary examination in person, April 15th, 2025, 9 a.m. That's before me in both matters. Bond will continue.
Thank you, Your Honor.
You're on the same. Yes. They don't have one. Okay, I'll call him up in a moment.
Okay, no problem. Tell me.
I lost. Do they have anybody?
There's nobody right there because we're down to just. We're down
Oh,
to just.
yes, I want.
Yeah, but they didn't call.
Court calls the case people versus Brendan Chrysler.
Pass along to people.
James Vitelski on behalf of Mr. Chrysler. Your Honor.
Your name, sir?
Brendan Chrysler. I have on my client's computer, it says medical portal from Beaumont, prescriptions for Xanax and Suboxone. I've also got a bottle here that is the alprazolam, which should be the one that's showing up as the benzodiazepine. So these are 2 substances my client is prescribed, taking as prescribed. So I've asked the court to.
Have you shown the people that?
I just saw the bottle and I believe that that's what it says in this portal. Mr. Vitelski is on the top. Yeah, I see it.
Okay.
And I'm familiar with both of those drugs, and I understand that they're prescribed substances, can be prescribed substances. In this case, it looks like they are.
And he has been in treatment, and Your Honor, I actually did have a.
How much in adjournment did you want?
3 weeks.
Probable cause conference, April 24th, 2025, 9 a.m. Bond continue.
And just so my client is clear, he has to continue a community correction, so I have him go back over there to set up the plan. Okay. Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you.
Same to your TV show.
Thank you for that, I guess. Wow. Well, no, what? Thank you. Oh, well, thanks. Appreciate it. You guys all knew I'm better looking in person. Wow. Court calls the case of People versus Elijah Craft.
And then on behalf of the Assistant Public Defender, Dr. Gary, Your Honor, on behalf of Mr. Elijah Craft. Mr. Craft, take your criminal case.
Thank you.
Just, we are requesting the adjournment.
April 24th, 2025, 9 a.m.
2, 3.
Can you what? That is 3 weeks.
That is 3 weeks.
That is 3 weeks. You can't count or?
You know, Judge,
I know. What? That was uncalled for? She can't count. I gave her 3 weeks and now she's yelling at me. Are you guys enjoying your conversation? Am I done?
Neither my client or myself, we get a date after the 24th that we can have. Sorry, Judge. I was doing so well today.
No, you weren't, but you were doing better than before. May 1st.
Thank you so much, Judge.
9 a.m. Bond continued. Thank you. Court does call the case of the People versus Nolan Crawford.
And I can, Mr. Crawford, just opening. Appreciate it, Judge.
Thank you.
Can I request for an adjournment?
Yes.
I know we're still waiting.
April 17th, 2025, 9 a.m. Bond will continue. Thank you. Court calls case of the People versus Harold Dennis.
Joseph and other people.
Yes. Second, Mr. Jenna. We are simply asking for we are attempting to mitigate circumstances. My client assured me that between Friday and Monday, what is being requested will be taken care of. Upon that, we're going to get a good offer from the prosecutor in this matter. So we're going to ask for a 2-week adjournment, but hopefully by Monday, this will be resolved in a positive fashion.
Without objection, April 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Durantu Francis.
People. And this is difficult. We're going to try to prepare because we are on behalf of my client who is on church.
All right.
Durantu Francis.
Thank you, ma'am.
You're welcome.
I don't know why it's stopped. All right.
Since we are.
It's a much better conversation than I normally do. Go ahead.
In
Yeah.
regards to the problem of conflict, we are asking for an adjournment as we are doing negotiations last time we were here. We submitted information to the court in regards to the test that Ms. Francis had completed. And I would just essentially is what should be approached on a judge.
Yes. All right, what are we doing with the case itself? But as to the violation, I'm not going to find a violation with the information that I have. I will indicate that the defendant may be placed back on a sober link. We'll fill out a new order, she'll have to report over to community corrections within the next 24 hours.
Thank you, Your Honor, and we just request an adjournment, Judge.
That's my understanding as well.
All right. And then I'll adjourn the hearing, the probable cause hearing to the 24th.
Thank you, Your Honor.
Thank you, Your Honor.
That's the 20. You're welcome.
I can leave now?
Sure. Bye.
Okay.
Yeah, is he here? Okay. Well, she's not. Court calls the case, People versus Brandon Carter.
Social development people.
So recall.
Afternoon, Your Honor. Stephanie Cannon with Capitol Road. Mr. Carter? Mr. Carter? Mr. Carter?
Hold on. Is he here?
Your Honor, Mr. Carter is not present. It appears I have broke my promise to the court.
I thought he was at St. Joe's driving pets.
These are the text messages that I have been receiving from my client, by and through. We get 30 minutes, Your Honor.
For what? Seriously? You want me to give you 30 minutes?
Yeah, I want you to give.
No, I want you to think about what you're asking me.
I'm just asking for some,
Grace, I've already done that.
grace. Have my time, Your Honor.
Do you,
I understand the court's position, however.
I have no position yet.
I'm sorry, say it again.
Do you think he is on his way?
Your Honor, I have 3 pictures of him busing it in. I just can't figure out where he's at on the bus. I understand, Your Honor.
Understand what? I have not said anything.
There's some words being spoken silently.
Yeah, there's a lot of those. All right. I'm going to give you a chance to redeem yourself.
Please, Your Honor.
So I'm going to pass it for 30 minutes.
Thank you, Your Honor.
And if he doesn't show up, I'm taking your whole office in. So,
No pressure at all.
court calls the case, People versus Stephen Kimura.
Stephanie Cannon, on behalf of Mr. Kimura, Your Honor.
Oh my goodness. Oh, are you sure?
I'm positive. I just had a conversation with him about adjourning his case so we can seek a resolution.
Is he going to join us?
Yes, Your Honor. I just asked you to bypass this case for just.
Another one?
Yes, Your Honor.
Court calls the case, People versus Latrice Lee. Is that yours too? No, it's gonna be Mr. Gaddy, because he's ready.
Absolutely.
Mike Gaddy is on behalf of Ms. Lee, reserve my right to state your name and say.
Thank you. What are we doing?
Your Honor, I haven't had a chance, Your Honor, I haven't had a chance to discuss the with you. We are trying to resolve it. I'd ask the court to review the adjournment so that we can continue talking about this case and we'll move it to the next CCC.
Probable cause conference will be adjourned to April 17th.
Thank you, Your Honor. And I'd ask the court if I can be heard on a bond condition.
The real Japanese Manjaro recipe blew up online and is helping women get rid of those stubborn love handles in just a few.
Yes.
Right, currently, Ms. Lee is alcohol and drug testing. She is, I'm not going to gild the lily. This case doesn't involve a high VAC. However, she has tested negative 6 times for any substances. We'd ask the court to discontinue the drug testing.
Any response from the people?
Your Honor, can the court tell me what she's on, a scram or a silver link?
I have ETG testing for alcohol 2 times per week.
So I don't, if there is going to be an order for some sort of scram or silver link, I would be fine with discontinuing the testing, but unless there's going to be that entered, this is a high BACO to be wise count too.
We'll address it in the next second.
I think that you might want to. The motion is denied at this time. Court call case Peter versus Matthew Wright.
Joseph McDonald. Good afternoon, Your Honor. Edward Sullivan.
Your name?
Matthew Wright.
All right, what are we doing? Discovery complete. People had their witnesses available the 15th.
We'll do our best, Your Honor.
Preliminary examination in person, April 15th, 2025, 9 a.m. Before me. Bond will continue.
My apologies, Your Honor. Briefly, I do have a jury trial that is scheduled for 14th in the morning on that Monday.
For the 14th.
So I know this is on a Tuesday in the event that it's the pay.
Then you need to talk to the people and try to figure it out and get with my staff. Yeah. All right. Thank you. Court calls case of the people versus Ado, is it Maynard?
And is that on behalf of the people, Your Honor?
Brian Bullock on behalf of Mr. Bader. Stated. Two.
Two. Gotcha.
Judge, we're asking for an exam.
All right. Discovery is complete.
Yeah, I believe.
People had their witnesses available the 15th.
We'll do our best, Your Honor.
All right. Preliminary examination in person, April 15th, 2025, 9 a.m. That's before Judge Moore. Bond will continue. Thank you. Thank you. Court calls the cases of the people versus Jeffrey Moore.
Mike Geddes, Assistant Public Defender. I called in the hallway and told my an explanation. It was, I asked a question.
Bench warrant will issue for defendant's failure to appear. Bond will be set in each case in the amount of 10,000 cash surety. Those warrants will issue immediately.
Ouch. That's what happens when you don't show up for court.
Court calls case people versus Marco Nanny.
Judge.
Oh.
Joseph Minola, figure. Afternoon.
Oh.
Assistant Public Defender on behalf of Mr.
Well, good seeing you, Mr. Fisher. We missed you. That's probably not true, but okay.
I recently received an email from my office that Mr. Mandy is currently hospitalized.
Okay.
I just moments ago, I requested a
You are aware there's a violation.
It's not, Your Honor.
Council approach. Oh, got it. Okay.
They've taken this video down 3 times because it teaches you how to hit lottery tickets every week. Watch now.
Okay, I see this and the information that Mr. Fisher you have. I'll grant an adjournment of probable cause, but just for 1 week to April 10th, 2025, 9 a.m. Bond continued.
Thank you very much.
Thank you. Court does call the case of the people versus Matthew Olet.
Josephine Olet, people.
Stephanie County had Mr. Alexis hearing to my right. Mr. Lake, New York, President, please state your name for the record.
I'm Matthew Olet.
Thank you.
And Your Honor, we are going to request a determination of our discussion prosecutor about it and hope to mitigate this down the field. I'm just asking for that to be here.
Probable cause conference will be adjourned April 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court calls the case, people versus Antoine Patterson.
Good afternoon, Your Honor. Marie Tanner, the prosecuting attorney.
Well, welcome back.
Thank you, Your Honor. Happy to be here.
I'm back after lunch.
Yeah, I know. Yeah, but you notice I didn't say anything, right? Just saying.
This is about the defender J. Don't know Mr. Patterson. Mr. Patterson, can you please say your name to the record?
Thank you. All right.
Your Honor, I have submitted further information for the prosecutor's consideration on offer. An offer has been previously made. We're attempting to negotiate further. I'm asking for 2 weeks in order to accomplish.
Any objection from the people? Probable cause conference, April 17th, 2025, 9 a.m. Bond continued. Thank you. Court calls case, people versus Jack Ritchie.
Good afternoon, Your Honor. Judge J on behalf of the people. This is about the defender J. Don't have Mr. Ritchie approaches. Mr. Ritchie, can you please see your name for the record? Jack Ritchie.
You're requesting an adjournment.
We are, Your Honor. We are, after further communication with the prosecution, we are requesting 30 days. My understanding is that more evidence is coming, and I also need the opportunity to talk to my client now that I have communication. That's correct, Your Honor. Waiting for a couple times.
Got it. Probable cause conference, May 1st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Have a good day.
That's it?
Yeah.
Hey, you have a good day too. Court calls the case, people versus Justin Robinson.
Right, well, let me have Mr. Robinson. Your Honor, we're asking for an adjournment to further do some further investigation related to the case and have further discussion with Mr. Robinson.
Probable cause conference, April 24th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Thank you. That's Caroline, I believe. Court calls case, people versus Romeo Serba.
Andrew Schultz is on behalf.
I'm Sheer here with on behalf of Mr. Rob.
Romeo Fairlawn.
Go ahead. You're requesting an adjournment.
Yes, I will take a mitigation report, request 3 to 4 weeks, if 4 weeks is possible.
No. Probable cause conference, April 24th, 2025, 9 a.m. Bond continued.
Great.
Thank you. Court calls the case of the people versus Julian K. Brown.
Absolutely.
Right, well, we're gonna be here. You shouldn't get president. You state your name for the record, sir?
Mr. K. Brown, can you state your name? He's got a bad connection, but I do see him.
Julian Tabron.
Yeah, I can see.
Heard him.
You did, okay. We're just asking, it's gonna be set for an exam.
Discovery is complete.
It is.
People have their witnesses available the 15th.
Try, thank you.
Preliminary examination in person, April 15th, 2025, 9 a.m. That is before me. That's in person. Bond continue. Court calls the case People versus Carl Tesson.
Brian Moore, on behalf of Mr. Tesson. Your Honor, we made a referral to the PD office, the Division of Health Services Provision to Mr. Tesson. Just kind of waiting for that to move a little further along in the process. So I just asked for probably calls.
May 1st, 2025, 9 a.m. Without objection, bond continue.
Thank you.
Court calls the case of the People versus Louis Feraldi.
Andrew Tola, appearing on behalf of the people.
As the chair, we are on behalf of Ms. Feraldi, who's appearing on Zoom.
Sir, can you please state your name?
Louis Feraldi.
All right, what are we doing? You're looking for an adjournment?
Yes, Your Honor.
You don't have a reason on here.
Apologies, the reason for the adjournment is the litigation report for.
Probable cause conference without objection. April 24th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls case People versus Vershawn Vincent.
What if you can create your own website by saying, this is what I want? With Wix, you can.
People.
Feel like cannon.
Conversation this apple. I thought he was going to be here, and I was going to ask for an adjournment. I do not know why he's not present. I would still request adjournment.
My notice of the case does appear on March the 13th, eventual issue. Did that get recalled?
I think that's happened. That's happened. And now he's not here again. Bench warrant will issue for defendant failure to appear. Bond 10,000. Cash surety. Warrant will issue immediately.
Thank you, Judge.
Thank you. Court does call the case of the People versus Markeith Washington.
And this is not behalf of the people, Your Honor.
Better Judge, for showcase the assistant public defender of that, Mr. Washington.
Sorry, Your Honor.
No.
My name is Marquis Washington.
Thank you.
Your Honor, this I carry out the case. My understanding is all discrepancy has been proved, and
People have their witnesses available the 15th.
We'll do our best, Your Honor.
Preliminary examination in person, April 15th, 2025, 9 a.m. That is before Judge Moore. Bond will continue. Thank you. Thank you, sir.
Your Honor, the next case refers to Spanish interpreter.
Okay.
Good afternoon, Mariana. You're in front of the Honorable J Cedric Simpson out of 14th District Court, Washington County, State of Michigan. We need your assistance with one matter this afternoon. Our number is 1423.
Thank you for that.
Thank you. When you're ready, can you please turn on your camera and raise your right hand to be sworn?
I'm ready.
I need a camera.
We need your camera on, ma'am.
Yes. I'm so sorry. Give me a second.
It's okay.
Okay.
All right.
Thank you very much. Do you solemnly swear or affirm that you'll interpret accurately, completely, impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in a manner now before the court to help you God?
Yes, I do.
All right, thank you. Good afternoon, Madam Interpreter.
Good afternoon, Your Honor.
Court does call the case of the people of the state of Michigan versus Sergio Romero.
Se inicia la sesión del Estado de Michigan versus Sergio Romero.
Prosecutor Rachel McDuffie for the people.
Were you able to pick that up, Madam Interpreter?
I'm so sorry. If you can please repeat. The voice is
Yes,
kind
it
of
was
hard.
Prosecutor Rachel McDuffie for the people.
La abogada Rachel McDuffie representando a las personas.
Chelsea Virgils with and on behalf of Sergio Romero.
Tenemos presente a Sergio Romero.
State your name, please.
She's not picking it up. Could you state your name, please, sir?
Por favor, puede dar su nombre.
Sergio Salazar Romero.
Yeah, yeah.
Your Honor, we are asking to adjourn this to continue a plea discussion.
I'm so sorry. The voice is very far. Can you please repeat?
Yes, they're asking to adjourn the matter to continue plea discussions.
Están pidiendo que se levante la sesión para terminar las conversaciones.
Ms. Virgils, I think also mentioned offline about an immigration attorney. I just wanted to.
Just no. Council approach.
Vamos a levantar la sesión por este tema.
May 1st, 2025, 9 a.m.
Hasta el día 1 de mayo del 2025 a las 9 de la mañana.
Bond will continue. Thank you.
Ahí continuamos. Gracias.
Thank you.
Thank you, Madam.
Wow. But like I said, these are real cases from real judges in real court. Well, that's it for today's docket. Again, to all the new subscribers, thank you for subscribing and welcome to my platform and to my channel. If you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to this channel. By doing so, you are supporting a very wonderful and loving community and a wonderful platform. I'm your host, Daniel. Ta-ta, ciao, ciao. I will see you again tomorrow for Judge Boyd's docket. So you all have a wonderful evening, and I will see you again soon.
Fix it all, solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's over.